Welcome back. You are watching Newscentre. The Supreme Court has agreed to hear a petition challenging the remission granted by the Gujarat government to 11 convicts in the Bilkis Bano case. The court has issued a notice to the Gujarat government seeking its response in 2 weeks. The release of the convicts has drawn severe condemnation from several activists and civil rights groups. The Gujarat government said it had relied on its remission policy of 1992 to approve the applications for early release. However, as per Section 435 of the Code of Criminal Procedure, a state government shall not exercise its remission power in case the matter is being probed by the CBI, except in consultation with the central government. It is not known if the Gujarat government had consulted the centre. Bilkis Bano was 5 months pregnant when she was gang raped on the 3rd of March 2002 during the post-Gotra riots. Several of her family members, including her 3-year-old daughter, were killed by a mob in 2004. The Supreme Court ordered CBI to probe the matter. This after the National Human Rights Commission intervened and ensured legal assistance for Bano to approach the apex court. In 2004, the case was transferred from Gujarat to Maharashtra as Bano dealt with death threats. In 2008, a CBI special court upheld the conviction of 13 accused, sentenced 11 to life imprisonment. The Bombay High Court upheld the order in 2017. Joining me now to discuss this further is Abha Singh, human rights lawyer. Thank you very much for joining us. Abha Singh, give us a sense of the questions that are likely to be raised before the Supreme Court. One, of course, is what advice did the state government get from the centre? On what basis did it rely on the remission policy? Did they also need to take permission from the judge who had passed the judgment initially convicting the 11 accused? What are the big questions before the court, Abha Singh?
You know, the bench, when today it asked Gujarat government for a reply, Justice Rastogi was on the bench and he said that we are only concerned if remission was in parameters of law. And then this judge further goes on to say that merely because the act was horrific, is that sufficient to say that it is wrong? So these are the two things which Supreme Court is going to look into, that whether this remission was as part of the law, because if we go by the law, 1992 law which was passed in 1992, what were the guidelines? I would say the guidelines for remission. It said 14 years if you've completed your punishment, you know, and in this case, life, death sentence was not, it was life imprisonment. And at that time, when the 1992 guidelines were prevalent, that life imprisonment meant 14 years. So it could be 14 years, and I think that is what they've said, that they've completed 14 years. But you rightly said that under 435 of the CRPC, which clearly said that if the central government is involved, in this case the CBI was involved, you should have taken permission from the central government. So now that they will have to give a reply whether CBI issue was taken or not. But what I am aghast, that, you know what Justice Ramanna said, he said that we only said you consider it. So, but I want to say that it is the apex court, and when apex court says consider, lot of state governments go ahead and think that it is a green signal from the Supreme Court. But here Justice Ramanna clearly says that I read somewhere that the Supreme Court has granted permission for remission, but no, we only said to consider. My question is that even if such things come to the Supreme Court should not pay any attention. It should throw them out. If you see certain SLPs, when they come out of 100 beds, one is admitted. So here this was rarest of the rare. A woman was not only raped, her 3-year-old child was killed, and she was pregnant at that time. I would call it rarest of the rare. At that time, we did not have death penalty for rape. It came only after Nirbhaya 2013. So had it been that time, these people would have got death penalty. So a person who's not got death penalty, you are giving him remission. That is the biggest issue.
Okay. Abha Singh, it is also being said that the remission policy of 1992 of the Gujarat government is outdated. And the manner in which these 11 accused were released on the 15th of August, they were welcomed also on their release. Do you think this raises questions?
Of course, it puts a very bad picture not only of the country but of the society, that you are garlanding rapists, you are welcoming them. men who acted like animals on a pregnant woman who killed her 3-year-old child. It shows that the society is divided on caste lines, society is divided on religion lines, and you are ready to condone such a horrific behavior because it is you are divided on certain ideologies. This is absolutely wrong. I think it is not a good sign for the country if it is heading to such a thing. And also, why did these people accept? I think they were so feeling proud of raping a woman, proud of killing a 3-year-old child. So this itself gives a wrong signal. And in fact, I really appreciate Justice Sujata Manohar when she says that this clearly shows that there is a dilution of rule of law. So with so many activists coming forward, even the judiciary, Justice Salvi, who had read out the punishment, who gave death imprisonment, said, I was not even consulted. That is another clause. The judge who had given out meted out the sentence, he should be consulted. But yes, the Gujarat government is going to say that we went by the 1992 policy, and it says these people had completed 14 years, so we gave them remission. Because today when the thing was going on, the bench also said, day in and day out, remission is granted to convicts of life sentence. What is the exception? So there we want to tell them, okay, you give remission. That is what Gujarat government is going to say, that day in and day out, remission is granted on 15th August, 26th January. But please remember that what you are giving out is to rapists, murderers. That is a heinous offense, rarest of the rare. So you cannot have such a policy. This policy needs to be checked. In fact, if you see in the West, you see in US, people for such heinous offenses, terror, rape, they are given 30 years, 40 years. Life means full life. And I think these 92 policy or whatever these policies are need to be set aside.
Abha Singh, I'd also like to ask you that now when it comes to Supreme Court, what has been the precedent when it comes to questioning pardons which have been granted by the governor or the president for that matter?
See, I mean, if you go by the Kehar Singh versus Union of India, the court, the Supreme Court, this was 1989, the Supreme Court clearly said that you cannot deny a prisoner the benefit to be considered for remission of sentence, as by doing so, prisoner would have to live all his life in the prison until the last breath without a ray of hope to be free again. And the Supreme Court said that this is against the principles of reformation, because we believe that the criminal justice system is also reformatory. Again, Supreme Court in a precedent, as you talk of, in state of Haryana versus Mahendra Singh, 2007, it said that even though no convict has a fundamental right of remission or shortening of sentence, the state, in the exercise of its executive power of remission, must consider each individual case. So then the executive here, the president and the governor, they have under Article 72 and 167 of the Constitution of India, they can pardon. But under the CRPC, it is 433 and 432 which talks of remission. But issue is, because these two cases are always quoted, Kehar Singh versus Union of India and State of Haryana versus Mahendra Singh, so that is why the Supreme Court, this precarious situation has arisen.
Right. So you are saying that there are legal precedents because of which there is a precarious situation. But coming back to the facts of this present case, do you think the activists who have gone to the Supreme Court challenging the remission granted by the Gujarat government in this case, do they have a strong case? Are the facts of this case different from the other precedents that have been cited by you? Is there a strong chance or strong evidence in their case?
You know, if I go by what is the whole criminal justice system about? Justice. You know, the justice, and justice should not only be delivered, but it should appear to be delivered. So here the issue, of course, here the bench says, I mean, if a sitting judge of the bench says merely because the act was horrific, is that sufficient to say that remission is wrong? He himself is saying this, that, okay, we have to only see whether it is within the parameters of law. But my question is, this pertains to women's safety. It pertains to safety of a girl child. It pertains to when you talk of empowering the girl child, when you talk of Beti Bachao, Beti Badhao. So the message which goes that you rape a woman, you murder her child, and yet you can go scot-free. You cannot be a soft state. On one side, after Nirbhaya, you came with death penalty. So, of course, criminal justice system does not talk of retrospective effect, and that is why they have been benefited under the 1992 policy, not under the 2014, which talked of life imprisonment, which also meant your good life, your full healthy life. So, of course, this is going to be a tricky situation, but my question is, the activists are very right in going to the Supreme Court, because the justice is enraged. Your rule of law is not followed, because number one, you did not take the permission, you did not take the decision or the advice of the judge who gave the sentence. Then what I have read among the papers, that the people who were on the committee belong to a particular ideology. So these things, you have to be transparent, you have to be fair, and for a heinous offense, you give remission for people. In fact, even during COVID, when the Supreme Court talked of commuting sentences or reducing sentences, it said people who were going under, who were under imprisonment for a punishment which was up to 7 years. But here, this is such a serious matter. So I think the court should, they have the powers to reject this remission and ensure that these people are rearrested.
All right. Thank you very much for putting the legal precedents and the facts of this case before us, Abha Singh. With that, it's a wrap on this edition of News Centre. Thank you for watching. Goodbye.